Irrevocable trusts are very powerful tools when planning ahead to preserve your assets for your family and to avoid or lessen the burden of Medicaid's strict financial guidelines. But some people get a little nervous about what sounds so permanent or set in stone when it comes to an irrevocable trust. So they ask the question, really? I can't revoke the trust, I can't change the trust. My name is Patrick Cawley. I'm with Keystone Elder Law in Mechanicsburg, Pennsylvania, and I want to tell you about Sarah, a recent client that I had. Sarah is in her early 60s. She has a son and a daughter. Sarah has seen too many people with dementia or Parkinson's or people who had a stroke or even cancer. All of these are conditions that can lead to long-term skilled nursing care, and really nothing pays for that most of the time except for Medicaid. Sarah saw these people go through the emotional strain of the family, the worry about finances. She has seen people lose property because of Medicaid and the way that it works. Planning ahead with a trust makes an awful lot of sense, and I explained that to Sarah. But her concern was, irrevocable sounds awfully permanent. What happens if her circumstances change in the future? What if her children bring grandchildren into the world and Sarah wants them to be recipients of trust property she preserved for exactly this reason? What if she has a falling out with somebody and wants that person out of the estate plan? What if she simply changes her mind? For example, what if down the road one of her children provides an awful lot of care and support at great sacrifice to the child, and Sarah wants to change her estate plan to favor that child, to reward all of that sacrifice? My answer is all of that can be done, even with an irrevocable trust. So here's a couple ways that it could work. One, Sarah's trust should be drafted to include a provision called a power of appointment. What the power of appointment means is in her will, which she may change at any time as long as she still has the cognitive capacity to sign documents, she can change her will and exercise the power of appointment that is in her trust. What that means is she's now saying in her will, she's changing the list of people who receive property from the trust. So it could go from person A and person B by a change of the will to person D, E, and F. And so she can simply change through the power of appointment, change her will to change who gets trust property. But what if circumstances changed and she wanted to dissolve the trust altogether, meaning she wants to revoke it? Well, whoever's named as the beneficiary of the trust can agree to that, and if they are in agreement, then the whole trust can in fact be revoked. So it's not as permanent as it might sound. Trusts are very powerful. They preserve assets, and really they save your family an awful lot of worry about money and worry about your care because you have preserved assets. This is especially important if you have a spouse who's going to be at home. You want to preserve assets for the spouse to live on when you have very expensive long-term care. This is just one more way to take that concern away. And it's not as permanent or set in stone as it might sound. So I hope this has been helpful to you. If you have questions, please leave a question or a comment to this video or send an email to me at info@KeystoneElderLaw.com. That's info@KeystoneElderLaw.com. And I strongly encourage you to get in touch about talking about trust planning well in advance of getting sick so that you can preserve your assets for your family.